I owe a mortgage on my home. When I die, will the mortgage company come and take the home away? Usually this worry is stemming from the due on sale clause that happens in most of the mortgage contracts that people get into with lenders. However, there are some certain exemptions where the due on sale clause will not be triggered. Let's talk about it. Hi everyone, my name is Leah Boston. I'm an estate planning attorney and owner of Law Office of Leah Boston LLC. I draft wills, trusts, and I talk about long-term life care planning with people like you. So if you didn't know, there's something called the Garn Germain Depository Institutions Act of 1982. And this act is especially put in place to protect people that are inheriting property with a mortgage and to stop those mortgage lenders from triggering the due on sale clause, which means accelerating the mortgage and making it all payable or all due once there's any sort of transfer. Of course, there's always exceptions to the exceptions, but this will be a broad overview. Let's chat about it. Due on sale clauses are mechanisms that allow mortgage companies to essentially trigger or demand the remaining balance of the mortgage payment when there is a transfer of the title to the property. This act that I was talking about is actually an exception to the due on sale clause, and it protects and provides certain rights to surviving spouses, surviving joint tenants with the right of survivorship, surviving tenants by the entirety, and relatives who inherit a home that already has an existing mortgage. So how does this work and who's protected? This act protects when a homeowner dies and devises their property to a family member, either through their will or the family member inherits by way of intestate succession. Under this act, that relative can actually reside in the property and continue to make the mortgage payments under the original terms of the loan. Other individuals that are protected under this act are joint tenants with the right of survivorship and tenants by the entirety. So for joint tenants with the right of survivorship and tenancy by the entirety, this is language that essentially means that the co-owners each own 50% of the property. And when one of the co-owners died, the surviving co-owner now owns a 100% of the property, and the property is immediately transferred to the surviving co-owner. Another popular estate planning transfer of property mechanism that people usually use is a revocable living trust. In this case, under the act, the lender cannot exercise its option to trigger the due on sale clause when there's a transfer of the property into a living trust, where the borrower is and remains a beneficiary of the property and still has the right to occupy the property. There are a couple of more scenarios that allow an individual to inherit a property without triggering that due on sale clause that's protected under the Garn Germain Act. However, I can go into those in another video, but I just wanted to give you a brief overview that talks about people being afraid essentially of their property basically being due when they die, or the people that are inheriting the property being afraid that they're going to lose the home that they inherited. These few scenarios that I stated earlier are going to be a couple of the exceptions that allow a person to keep that property and not have to owe the mortgage immediately once they inherit. If you have any questions or want me to delve deeper into this topic, please let me know in the comments. And if you'd like to get started on your estate planning, please don't hesitate to contact my office at www.leahbostonlaw.com, and I'm happy to help get you started. See you in the next video. Bye.